Sorry about that, everyone. I think I'm recording now, and I think I'm screen sharing. I think my microphone is turned on so you all can hear me. In tonight's video, I'm going to be talking about Bobbitt's piece, The Modalities of Constitutional Interpretation. Now, for the purposes of this course, I will de-emphasize this article just a bit in favor of the second article this week. And so this video is going to be relatively shorter in duration than the one I'll post tomorrow night. For now, we can think about Philip Bobbitt's Modalities of Constitutional Interpretation. Now, this reading is somewhat of a turning point in the course, because in the previous module, we learned about a very paradigmatic form of legal reasoning in which lawyers will try to make arguments that favor their clients by tying a legal rule to the facts of a particular case. Meanwhile, there is an adversary, another lawyer on the other side, who tries to do this thing, except they'll try to tie facts of the case to a different rule that, when followed, would favor their client. Again, a very commonly encountered form of legal reasoning, but we'll set that kind of legal reasoning aside now. Returning now to think about a second kind of legal reasoning in which one tries to figure out the meaning of a law, where, by the way, the law is reasonably susceptible to one, two, or three kinds of interpretations. Sometimes you might see a law and think, oh, this law will govern this kind of case. But somebody else might come along with a different interpretation of that law and say, no, this law was intended to govern only this kind of case. We're now interested in questions about the interpretation of laws. And so Philip Bobbitt's Modalities of Constitutional Interpretation is a piece that chronicles the way of making arguments about interpretation that would count as acceptable. When I first began teaching this course, I thought the use of the term modality was manifestly unhelpful. I had no idea what a modality was. And it is kind of stipulative at the end of the day. But after years of teaching this, I've just kind of accepted the fact that modality is what I've begun to say as well. But when I use the term modality, as does Bobbitt, we just mean a way of arguing about the interpretation of something. What counts as a good interpretation? What counts as a good interpretation will be given by a modality. There are 6 modalities that we'll think about in this lecture. The first modality derives from history, the second from the text itself and how it would be understood, the third from these structural arguments about the government, the fourth from doctrine or precedent, the fifth from ethos, and the sixth from prudence. Let me go through each of these systematically and make this short video for you tonight. So the first modality that we'll think about is history. When we engage in historical analysis, what we're trying to do is figure out the meaning of a law by appealing to the intentions of those people who wrote the law. This is commonly encountered, by the way, with modern discourse over the Second Amendment, for example. People say there's a right to keep and bear arms and it shall not be infringed. But what kind of cases of arm ownership and bearing is that supposed to cover? And when people try to settle the answers to that, to settle on an answer to that question, they'll oftentimes try to consult the intentions of the people who wrote the Constitution, right? In doing so, they're engaging in a kind of historical analysis. They're appealing to a historical modality. Arguably, though, you can apply these kinds of interpretive arguments to more than just the Constitution and laws. You can apply it to all sorts of mediums of communication. You can apply it to song lyrics. I've thought about the ambiguous lyric from Jimi Hendrix, where some people hear him say, "Excuse me while I kiss this guy," or "Is it kiss the sky?" You know, I'll leave it for you to look up if you don't already know, but people have thought it to be ambiguous. They've misheard the lyric. But when they find out what Jimmy's intention was, when they find those lyrics that he wrote that are transcribed in the dust jacket or the jewel case of a CD or wherever they found these lyrics, something about finding out the answer to that question settles it for them. They realize that he meant, "Excuse me while I'll kiss the sky," and not, "Excuse me while I kiss this guy," right? Something about finding out the author's intention settles the question about what the meaning of his song is. And so it almost seems to me that when we find out the author's intention, it will fix in many ways what the meaning of a text should be. Now, in the law, it's a little bit more problematic because there are so many different authors of the law. It's not like a Jimi Hendrix song where you could just look up the intention of a sole author and find out what they meant. You have to consult so many different authors, specifically with the Constitution, also with congressional, codes promulgated by the U.S. Congress and that sort of thing. You'd have to look at a lot of different intentions and make a lot of different judgments en route to find out what exactly the intentions of the authors were. But supposing you could do that, there is also another problem that confronts us, and that is the issue of circularity, right? I mean, with the Constitution in particular, since that's what this lecture is supposed to be about, have we ever found any intention from those who wrote the Constitution that if there were some kind of ambiguity that arose with respect to constitutional interpretation, that to settle that ambiguity, we must consult the interpretation or the intention, really, of the framers? It's kind of an odd question. Another way of putting this worry is just to say, okay, suppose that we are to consult the intention of the authors of a law whenever we try to resolve ambiguities, but they themselves never manifested any kind of intention for us to consult their intentions. So it's kind of odd that we would appeal to their intention as the final arbiter of meaning with respect to some laws. I'll leave you to think about that and ways you might get around that kind of a worry. I'm not too concerned with this myself. What I want to figure out, though, is do we find some kind of intuitive pull whenever we learn about the author's intention? If you were to listen to, say, Taylor Swift say, at tea time, everybody agrees, you might think, knowing nothing else about the way people gossip around tea or something like that, you might think that at tea time, it's ambiguous between somebody playing golf and somebody drinking tea, right? And so if you were trying to figure out whether Taylor Swift was a golfer or a tea drinker, how would you settle the question? Well, again, if you were to look up the lyrics that she herself wrote for her song, and you saw this on the internet somewhere, and once you saw it meant drinking tea and not playing golf, you might think the issue is permanently settled in your mind. It could never be a song about golf at that point. It could never be a song about a golf outing. It would always, in perpetuity, in succession from that moment, it would be about drinking tea in your mind. The issue would be settled, I think. And so, are laws any different? If we were to figure out dispositive, decisive evidence that the author of a law meant something when they wrote it, but the thing that they actually wrote was ambiguous in one way or another because of something that they didn't foresee, would their intention fix the meaning of a law just like it does the meaning of lyrics when we learn them? It's a question to worry about. But there is some sort of pull, I think, that most people will feel toward the idea that at least sometimes what an author intended should fix the meaning of the thing being interpreted, in this case, the Constitution. Now, suppose that for whatever reason, the author's intention is inaccessible. Perhaps they never wrote it down. Perhaps there's no record of what they thought. Perhaps there's no record of what they intended. Is this modality of text the second best thing that we could appeal to? Or is it just its own source of authority for the goodness of an interpretation? Let's figure out what text is first, and then we can think about that on your own time. When one makes a textual argument, what one is doing is appealing to the way that some audience would have understood the law. Now, in the text, Bobbitt is very hung up on the idea that a modern American audience would have a meaning that they would supply to a text or a law. But there are flavors of textualism that extend beyond just modern audiences, of course. The contemporary audience of the law as it was initially promulgated would be especially interesting. So when we think about the Constitution, think about when it was first promulgated, when people were first learning about what it meant. And if that audience would have understood the law in a particular way, you might think that that kind of understanding would be good evidence about what the text means. Supposing that we don't have the right access to the author's intention or something like that. Suppose the two differed, though. Suppose that you have good historical evidence that the authors intended for something to be the case, but when they actually published the law, the public would have had a vastly different understanding because of legalese or something else that crept in. What do you do in those sorts of cases? Do you still feel the same pull toward the author's intention? Or do you think the author's intention and the presumption in its favor can be defeated by the common understanding that someone may have had? Well, I can't settle those questions for you. They're far too complicated for me. But at least history and text make up the first two of the modalities we'll learn about. The third kind of modality that I'll talk about is this one that relates to the notion of structure. When one makes a structural argument, all one's doing is appealing to the function of a particular part of the government. So in the United States, for example, we have all these different parts of the government, right? Legislative, judicial, executive branches. We have federal governments and we have state governments. And we have all these divisions with respect to the government because they're all supposed to do different things. They exist as separate branches, as separate kinds of government, for a lot of different reasons. And if we could figure out what those reasons were, we'd be making an argument about the function, the proper function, or the purpose of the government. Now, when a particular practice would do something that undermines the function of that branch of government, it's a reason for rejecting that practice. And a structural argument kind of gives those reasons. So suppose the purpose of the executive branch is to execute a law. If it could be shown that a practice resulted in the executive branch not executing a law, giving that power instead to another branch of government, such as the judicial branch, then this would be a reason for rejecting that law, and doing so would be on the basis of a structural argument. Now, one who accepts a historical kind of modality, or a textual modality, or a structural modality, one who accepts these three kinds of argument is called a strict constructionist. Some figures historically in the court have held to this kind of hierarchy. Typically, one would look to first the author's intention, and if that's unavailable, then to the text. And then lastly, they would make these arguments from the structure of the government. And if you accept only these three forms of government interpretation, then you'd be a strict constructionist. While we're powering through these modalities, let's talk about the last three. The fourth modality is really the easiest one to remember. It's called doctrine in the text, but you're all familiar with this. The idea that a case should be decided in accordance with the way the previous cases have been decided. In this way, you're appealing to precedent, or we've heard about the doctrine of stare decisis in America, but this fourth modality of doctrine just reminds us that a good interpretation is one that is in accordance with what's previously been decided. Now, of course, arguments from doctrine will be unavailable when a case is novel, but the thought was never that doctrine was the only acceptable means of interpretation, just that it's an acceptable one. Another kind of interpretation to which one might appeal would be that of ethos. This idea, basically, to put it very bluntly, jurists have fancied themselves to be discoverers of natural rights for a long time. In fact, the push to view the law degree as a doctorate, as a scientific kind of degree, presupposes a view about natural rights in which it's almost silly to say this, but they're almost like features of the world. Just as physical laws were discovered, such as those of gravity and pressure and whatnot. Jurists have fancied themselves as those kind of looking in the world for human rights. And so, in the Ninth Amendment in particular, there's this idea enshrined forever in the Constitution that there are some rights that just weren't written down because there are other rights out there that might be discovered in the future. Some kinds of constitutional interpretation appeal to the idea that a new, as of yet undiscovered human right has been unearthed. And it's very much in line with those principles that were, whenever discovered, will become part of the Constitution. Uh, Whenever you can discover a new natural right or a new human right, it's just presumed to be the kind of thing that would be acceptable and in line with the Constitution, if you can show that it isn't the product of your imagination or discovery, but it genuinely is a human right that's been discovered. In fact, in what follows in the course, we're going to look at quite a few examples of cases in which people have purported to find new natural rights, new constitutional rights. And then there are all these skeptical dialogues about whether, in fact, these rights were just the product of a judge's imagination, whether they really were genuine rights in some sense of the term. But when you appeal to human rights that have not been written in the Constitution itself, you're appealing in some way to an ethical argument. The last kind of modality is that of prudence. It involves a kind of weighing and a cost-benefit analysis. We saw in the text, for instance, this example that I thought was quite interesting. The example was there is a constitutional prohibition against the federal government becoming embroiled in private contracts, except that in some cases, it might be a good thing for the government to embroil themselves in private contracts, to interfere in private contracts for the greater good. So when you're thinking about social policy in utilitarian terms, it's a good sign that you're making a prudential argument. I really don't want to dwell on the modalities too much. The interesting philosophical questions to me just deal with what happens when they conflict, or what happens when all of the means of interpretation lead to a bad result. So let's spend some time at least thinking about what would happen in all of these cases. I've often thought that perhaps sometimes what people mean when they talk about interpretation could be twofold. They might mean, on one hand, what does a statute mean, just as they meant what does a Taylor Swift song mean, or what does a movie mean, or what does a religious text mean? But in another sense, they might be interested with what should be done. Suppose you have a law, and suppose it's very bad. Suppose that the authors who wrote it had evil intentions. Suppose that everyone at the time of its promulgation would have understood it to have evil effects. Suppose that the very nature of the government in some way is predicated on the possibility of an autocratic government with the authority to perpetuate such evil acts. It's part of the nature of the government itself that it does such things. Next, suppose that all costs and benefits support the doing of an evil act in a society. After all, according to utilitarianism, sometimes it seems like if the most people will be happy from it, if you'll produce the most pleasure over pain by doing something, it can sometimes be all right to oppress a minority. All according to utilitarianism, right? Suppose, moreover, that these natural rights that are being discovered, they don't extend to a certain class of people or something like that. You can tell stories about how they wouldn't extend to those people. And lastly, suppose all of your pre-existing jurisprudence, all of your case law before this, supports the idea that you ought to do the evil thing. Are there separate questions at issue here? You might think, on one hand, well, of course the law just means this bad thing. Of course the law means this discriminatory, bad, evil thing. But then there's a separate question at issue. What should the judge hearing the case do? Should he do that which is in accordance with the evil law? or should he interpose himself? And so I think a lot of times these questions get illicitly blended together when we think about interpretation. We set aside questions about what a law means because we oftentimes have moral views about what should be done in a particular case. I'm guilty of this at least. I mean, I might be willing to accept that a law, that an author's intention sometimes fixes the meaning of a law, but all things considered, I don't think a judge ought to follow the law. Other people have different views about what the judge's role is. Many people, maybe myself included, I'm not sure, they view the judge as constrained by uh, the judge is like a historian. The judge is supposed to figure out what the law meant according to those who wrote it. The judge is supposed to figure out what the law meant according to those who originally heard it. And the judge is supposed to be competent with, some basic ideas about government. You put all these facts into the judge, and, the judge is basically a computer that plops out, a unique legal verdict, and that's the meaning of a law. The judge is just this arbiter about the historical facts. He's not really doing anything on his own or her own or whatnot. Other people think that basically the most important thing for a judge to do is to do the moral thing, to do that which is in accordance with true morality, or the morality of the day at least. Now, I think both of these kind of approaches to interpretation are going to run afoul of some problems, right? I mean, to the one who thinks that basically only history, text, and structure are relevant, that kind of thinker has to confront the question about what to do when the history, text, and structure are all bad. Suppose something that is enshrined in the very nature of the government and its laws and the intentions of those who wrote it and the way everyone would have understood it. Suppose all of that tells in favor of doing something that's morally bad and that's oppressive. Ought the judge to do that thing? Intuitively not, right? But how can the judge not do it? Well, there has to be some kind of ad hoc story about how there's this true morality kind of in the subscript of the text of the law, and that maybe the judge is really just getting that out. But I don't know about you. As for me, I'm always a little bit suspicious about these stories. In contrast to the person who always thinks that the judge ought to do what's in accordance with their morality or their view, what is the purpose of the law at all? Why don't we just have judges making cases in succession? It's a question. What is the purpose of a law and interpretation in the first place if the judge will just do whatever they think is in accordance with their morality or true morality, if we're optimistic? Won't those decisions always be arbitrary? So I think that there are tricky questions that we'll have to confront in this class. Some of them, though, you might more neatly distinguish by just thinking about drawing a distinction between the meaning of a statute and thinking about what a judge should do. Okay. So I think that's all I want to say in this video. Basically, the takeaway for this video is that there are 6 ways, at least, of arguing for what the meaning of a law is. They're pretty much all given by these 6 modalities. I've not been able to think of any others. And as you go through in the next few weeks, you'll be reading cases from the constitutional law and probably arguments being made by the lawyers in either side will just jump out at you as belonging to one of these 6 categories. Now, it's not super important for the next writing assignment that you master what kinds of arguments are being made, although I might ask you in the future. For now, it's just interesting to see that these are supposed to be the kinds of reasoning that count as good. And various people will have different views about what modalities in fact are good. Some might reject some and accept others, but there are puzzles. Another thing that we should think about just as we close is what should we do when these modalities conflict? So suppose, once more, the author's intentions tell in one direction, but they've written something that nobody would understand to be that which they've intended, right? Suppose the authors intended to say that, only a musket could be owned, but the way they've written it is so ambiguous, no one would draw that conclusion, right? Something like that. Then what do we do when these cases conflict? Here you have the author's intention going in one direction, and you have a common understanding going in another. You might have prudential arguments, cost-benefit analysis going in a completely different direction. Who knows? These modalities are bound to conflict. And so what do you do when they conflict? What kind of consideration ought to trump? It's tricky because everybody and their uncle has a view about which of these modalities is the best. And what do we do when these modalities conflict? Well, I don't have the answers for you. I wish I did, but you might think more about this as the semester goes on. There is some kind of intuitive pull toward the author's intention. At least we feel this in other areas of our life. The problem is that we all know that the people that write laws can be bad people, right? They can have bad intentions, and their bad intentions can be enshrined in the law, presupposed by it, or dependent on these bad views in some way. It's very interesting to think about what we should do then when the author's intention tells in one direction, but perhaps the ethos tells in a different direction. How should we break these ties? What should we do? I don't have the answers for you, but and what follows in the class, we'll be looking at the way courts have wrestled with some of these issues historically. Particularly in this course, I've kind of given you a sample platter of the way these kind of issues have arisen in the example of abortion. So we'll begin by looking at Griswold versus Connecticut, where basically the court creates a non-textual right to privacy. Later, that right expands to include abortion. Later in Planned Parenthood versus Casey, that kind of reasoning is scrapped in favor of some other kind of analysis. And we'll look at Dobbs versus Jackson, in which, basically all of that goes out the window, and there is no constitutional right to an abortion, at least from the reasoning of that case. And it's clear there that what we've seen is basically the court began with a kind of ethical argument. They've begun with the ethical argument that there are these unenshrined, unenumerated rights that are floating around in nature, in the world somewhere, particularly the right of privacy, and that the judge have kind of finally gotten at it. They've captured it, they've written it down, they've put it into writing now so that future people can be protected, and so that the right may not be deprived without due process of law and that kind of thing. And so they're very much relying on an ethical argument when they establish a right of privacy. But of course, people will come along and say the authors never intended for there to be such a right, or people wouldn't have understood there to be such a right of privacy just by reading the text. And it doesn't seem to be implied by any of the structure of government, and it's certainly not implied by any kind of doctrine or precedent that came before. And so what are we to do with this ethical argument? You'll basically see the rise and fall of errors of the Supreme Court based on which of these modalities of argument the court or the majority of its constituents hold to be persuasive at the time of the law's writing. So I think that'll be interesting for you, but again, probably not a cornerstone piece of the class that you master any of this. What I will ask you to master will be the content of the next lecture, which will involve Anita Allen's critique of privacy rights. I've put this piece at the beginning of the reading just so that we can all kind of have in mind distinctions that might be made. And basically what I'm going to teach you in the next lecture going forward is a kind of fallacy that could be made when thinking about a way certain terms might apply and how they affect the quality of legal reasoning. So I'm excited to share that with you tomorrow night, but for now, I hope you enjoyed this lecture on the modalities of constitutional argumentation. See you next time.